now we're going to go into our questions for today. As of right now, we have about 15 questions, so we'll just get started right on them. Okay, next question is from an owner. What recourse do unit owners have when the board signs a contract days before the special meeting to approve the contract? Okay, so it looks like owners are upset and the board signs a contract before the actual board approves the contract at a meeting. So they're getting, the cart in front of the horse, so to speak. It's not proper. The board should be signing contracts or voting to sign contracts at an open board meeting. If there was an emergency circumstance that, doing it outside of a board meeting may be acceptable, but it's really not a good procedure for your board to do that. And what recourse do you have? I suppose you could go to the Department of Real Estate, file a complaint against your board. You could, file litigation on this. Probably not something you're going to want to do just because there's probably no damages because they, quickly approved it after the fact. But it's kind of a sign to me that there might be something going on in your association if they are doing things like this in secret, absent an emergency. So I would keep an eye on your association's board for sure and make them aware that the way that they handle this needs to be changed going forward. Okay, next question is from a board member. We have a security camera inside the association's clubhouse. Since the clubhouse is a community asset reserved for board meetings, we use a camera to record board meetings. Homeowners can also reserve the clubhouse for gatherings. At the time the homeowner is using the clubhouse, are we required to turn off the camera? Our governing documents do not at this time have any specifications regarding security cameras. So I don't think, in my opinion, would be that, there's nothing under state law that I'm aware of that would, require you to turn those cameras off. It's your property. What you may want to do is just notify the owners that there is a camera, and it will, it does record things. You may even want to have a sign next to the camera stating that. You want to be careful that you don't, overpromise, though, because you probably don't have a live person there, watching the camera 24/7. So, but I don't have a problem with having the camera on even during private events, as long as whoever's using the facility understands and knows that there's a camera. And it would be helpful just for notice reasons that you may want to put a sign up. Okay, next question is for an association, a planned community. I'm not sure if it's a board member or homeowner. Okay, our HOAs were amended in 2019. The minimum rental period is 60 days for homes that change ownership after January 4th, 2019. We require an information form from each homeowner with contact information on the tenants, and we charge a $25 rental fee each time a new lease begins. We also state in writing that any homeowner who rents their home must file a residential rental property registration form with the Maricopa County Assessor, and we give them a hyperlink to the assessor's website. Do we have any responsibility beyond the alert to the renting homeowner that a registration form must be filed with the Maricopa County Assessor? So no, you don't have any responsibility. That responsibility is on the owner landlord to, take care of that. And it sounds like you're doing everything else, correct in compliance with Arizona law. Question number 4, what is a consent agenda and how can this be used to better manage HOA board meetings? Okay, a consent agenda it's used in city council meetings typically, for municipal governments, but I have seen it used in HOA or condo setting as well. And so basically you just line up the things that need to be approved on the agenda. And typically it's things that are not controversial and that can be quickly voted on. So for example, your association may have on the consent agenda to approve last month's meeting minutes and maybe to approve, certain financial information. And the board should have reviewed all these items before the board meetings. So it's easy for them to just vote yes when a motion's made to approve the entire consent agenda. Now, your board should not be doing the entire meeting, though, by a consent agenda, right? The things that we typically will see is maybe architectural applications, if there are non-controversial or not controversial ones. You may do a consent agenda to approve, 25 architectural approvals for things that are, allowable under your documents. That would be another time you could use it. If any board member doesn't want a certain item on the consent agenda, the board member can ask to have that consent agenda item moved off of the consent agenda and then voted on separately. That's something that can be done. I mean, not a lot of associations use consent agendas, but it can be a helpful tool to get through the meeting faster. Next question, number 5. A meeting was held on Saturday morning by a group of 20 to 25 homeowners. Flyers were placed on some homes inviting them to attend. A homeowner was asked to leave after the leader asked if anyone attending was on a board committee. Is this a valid meeting? Is the demands of the group sent to the board needed to be responded to since not all homeowners were allowed to attend? How would you recommend we handle? So I'm assuming that this person's a board member asking this question. And I don't know how large your association is. So I don't know if 20 to 25 homeowners is like 20% of your membership, or if it's 20 to 25 homeowners out of a 2,000 home association. So it's kind of hard for me to answer this question. But okay, the bottom line is that under the new law that we talked about under the new legislation, owners are allowed to peacefully assemble. So they, are allowed to do that. I suppose somebody, who is running the meeting can ask, somebody to lead the meeting. That's certainly their right. This is the common areas though, and you do have a right to be there. Not sure you really want to have a fist fight to stay, but, so obviously they have the right to ask somebody to leave if they want to, but that person has the right to stay there because they have an easement to use the common areas. So now the question transitions to, do we need to respond as a board to some of the demands from this meeting because they didn't let, some people come, or they didn't give notice to everybody? And I would say, I think this goes back to secrets of successful associations. If you have 20 to 25 people who are upset about an issue, you do need to respond, even though they may not have handled the meeting exactly how we would have liked and included everybody. But I think you should at least listen and respond, because that's part of our responsibility serving on the board, is, listening to the homeowners and what they want and responding in a professional and business-like manner. So I would respond. If you have 20 to 25 homeowners and you're a smaller association, like 100 or 200 units or lots, this raises some concern flags for me, for you as a board, that, hey, your homeowners aren't happy. And this might be a good time for a town hall meeting to air grievances and talk through issues, because the next thing that could happen would be they could start circulating a removal petition. Okay, next question. A past lack of increase in yearly HOA fees has left us in a pickle this year after large increases in most of our maintenance fees. What is the Arizona law regarding the limits we may raise the fees per year in order to prevent a loss in the value of our properties? Okay, so for this particular question, I need to see your CC&Rs. So your CC&Rs are going to outline, what percentage you can increase your dues each year, if you have any special exceptions, if the budget needs to be amended and maybe you might be able to increase it a certain percentage, or maybe you amend the budget, you can increase it. So bottom line is, you really got to look at your association's documents. There is a provision in the Planned Communities Act, but it doesn't apply to every planned community, and it would limit. So the one we would use it for associations would be, let's say that there is no limit in your CC&Rs to increase planned communities assessments every year. Well, there is a ceiling under the Planned Communities Act that if you're going to try to increase it more than 20% of the prior year's assessment, you'd have to get approval of the membership of 51% of the membership. So I think for your case, I would look at what your documents say to determine whether or not you need a vote of the membership and what percentage that you can increase the assessments. And you definitely want to get your legal counsel involved to help you and advise you on that. Okay, next question. In general, is amending existing CC&Rs more cost effective than rewriting them? It just depends. I guess I'm really not in favor of taking a current set of CC&Rs and just trashing them and starting completely over, because that change sometimes is too hard for the membership to swallow. Like it's hard to get votes to pass it. And there's exceptions to that, of course. If you have a really bad document to begin with, you might be just redlining the whole thing and starting over. But I do think that change is hard for members, and getting them to approve changes is difficult. And so taking the existing document and making changes to make it, in compliance with Arizona law and fresh and easy to read, and, getting rid of the developer language typically is a better strategy to get the votes. Okay, the HOA I'm part of does not communicate anything well, if at all, and started funding a reserve account a couple of years ago. What is the maximum amount that can be saved in this reserve account? Okay, so a good sign is that your association has, a reserve. They're planning for their reserves, which are the long-term capital, expenditures for the future. I'm not aware of any maximum, amount. There's no cap, under state law or anything like that. And so I think maybe what you need to do is go to a board meeting and ask a little bit about, tell me about how we're funding the reserve, and have you had a reserve study done by a reserve company? And you may want to look at our cheat sheet. We have a cheat sheet on reserve studies and reserve funds. That's on our website at mulcahylawfirm.com. And that might give you some good background information on how the reserve fund works and how reserve study works to better answer your question. Okay, next question, number 9. If the association has a happy hour for the community, would you have to post that a majority of the board members will be present? And so, no, if the board is there discussing, if a majority of the board is there discussing association business, yes. If a majority of the board is there socializing and not, quorum of the board, discussing association business or conducting a meeting during the happy hour, then no. You might want to be careful if this is a happy hour. I hate to be a buzzkill, but we got to be careful on alcohol and the association, sponsoring an event where there's alcohol. There may be some insurance issues with that and some liability issues with that. Okay, next question, number 10. We need a records retention rule or a policy. Is there an example available? Yes, I have a cheat sheet on this exact topic. So go to our website at mulcahylawfirm.com and click on our cheat sheet section, go to the records retention policy cheat sheet, and everything you need will be right there. Okay, number 11, what do you do when you have various committees and the committee members do not get along and literally fight among each other? Okay, what I typically will do, it depends on what committee it is, but if it's an important committee like budget, architectural, finance, we typically will have the attorney for the association come in and talk to the committee and explain that we're all on the committee for the same reason. We want what's best for the community. We may not all agree on what's best for the community, but we need to respect each other's opinions, and we need to respect that majority rules, and try to have like a boot camp to get them pointed in the right direction. Now, sometimes, you have different personalities and they just don't jive well together. So check out our cheat sheet on the DISC personality tests and how that can be helpful for your association to function at a higher level. We have that on our website. It's the DIS as in Sam C. It's basically just a test. And if we do a boot camp, it's the first thing I do with the group is we all take a personality test, because if there's fighting or level of dysfunction on the board, oftentimes it's because the personalities don't jive well together. And so taking that test and better understanding what the different personality types are may right then and there help people get along better. And if you ultimately can't get along better over time, then it might be a time to change out some members of the committee and put together a team that's going to work well together. Now, anybody who's had any sort of business or teams training, team building training, you know that in order to have an effective team, you need all different types of personalities. So, I laugh because I love the studying of personality types. I actually, whenever I go to a board meeting, I'm trying to determine what personality types the board members have, because I want to do a good job. And there are different personality types, like there's the D personality type where they want the answer fast. And they don't want me sitting there giving some flowery explanation, right? And long explanation would be like torture for them. But then there's other personality types like the C personality type where they want that detail. And if I short them on the detail, they're going to be upset. So I'm trying to balance in the room what my audience is. And it's kind of the same thing for when you have a committee that's not working well together. Maybe you have too many of one personality type, or maybe you have the clashing personality types that don't work well together sometimes. And when you have that clashing personality types on any team or any committee, just having everybody go in their corners and understanding, okay, this person wants to make a decision a little faster. This person needs all the information. How can we work together so that we meet the needs of both committee members? And so maybe the person that wants to make the decisions really fast, maybe they need to give 10 minutes to discuss things. And maybe the person that needs to, overanalyze and watch the paint dry, maybe we say to them, you're not going to get an hour to discuss this. Everybody's got to come together in the 10-minute time frame to get our questions answered and to resolve issues. So hopefully that will help you. Ultimately, the boot camp, using the personality testing, having your attorney come in and talk to the committee, and then ultimately restructuring the committee if it's just not working with the current people. Okay, next question. The bylaws state that there can be no less than 3 directors, nor more than 9 directors. The president quit. The VP is still operating as the vice president and is running meetings, and there is 1 member at large on the board. VP states that they are going to operate with just the 2 of them and have voted on matters. Is this legal? Okay, so let's look at, you can have no less than 3 directors. Right now you have 2. So my feeling is that you really should try to get up to 3, okay? Because the minimum, the bylaws say the minimum number of directors is 3. But that being said, with a 3-person board, typically a quorum is 2. And so the decisions that have been made by just the 2 of them likely are legal because that was a quorum of the board, right? But if I were advising this association, I would recommend that you seek candidates to fill that 3rd spot. Typically, the bylaws will give the remaining directors the ability to appoint a replacement director, or the president who resigned for that president's, not for the president position, but for the director at large position that the president also carried. And I would encourage you to try to get somebody to fill that spot so that you can meet that requirement of having 3 directors. Okay, next question, number 13. Since the current rule says that you need 67% to amend the CC&Rs, and the rule set in the current CC&Rs says 85% is needed, does that rule have to be followed? Or 67% rule, should that be followed? Okay, so let's see. So you're saying that the current rule says that you need 67%, and then the rule set in the current CC&Rs says that 85%. So I'm not really sure, this question is a little confusing to me. Whatever your current CC&Rs say, if it says 80%, 85%, I'd have to look at your documents to give you a formal opinion, but I think the CC&Rs are going to control here in terms of amending. The CC&Rs is going to take 85%. The only thing I'm going to say is I've been doing this a long time, 26 years. I don't think I've ever seen a set of CC&Rs that say 85%. So that's kind of weird. I've seen 67%, I've seen 90, 75%. So that kind of worries me a little bit, but go by what the CC&Rs say. If you're relying on the 67% from the Condominium Act, that only kicks in if your association, has a lower than 67, your condo association has a lower than 67% amendment requirement in the CC&Rs. In that case, you got to rely on what state law says, which pushes you up to, you have to get 67% approval to amend the CC&Rs in that condo. But it doesn't flip the other way. So it doesn't flip if your CC&Rs say higher than 67%, oh, we can take advantage of the 67% in the Condo Act. No, you can't do that. You have to follow what the CC&Rs say. Okay, last two questions. I have been trying to communicate with HOA managers since 2018. Finally, I just had an executive session or an executive meeting only for myself and the board. The board was unable to speak to me because I had a lawyer write a letter to obtain their attention. I was able to express my concerns. No response has been received. We only have a visitor parking that was created in 2020, but no resident parking or handicap parking available. Third-party monitoring has been inconsistent and causing residents to be upset. Towing only certain vehicles received warnings. I suggested amending our CC&Rs to the HOA attorney that was present at the executive meeting, maybe providing parking permits that we can pay and it would bring in revenue. But there's been no word from the board or the attorney. We have a 4-bedroom home, 2-car garage, home at the end of a shared driveway, and I have 4 drivers now in our home. How do I get someone to communicate with me? Okay, well, the good thing is that you want to communicate and you want to work this out with the board. And it looks like you hired an attorney. And I think probably since the board won't respond to you anymore because you have an attorney, I think you need to have your attorney communicate with the board and the board's attorney to try to resolve this. I don't know if you have, it says you have a 2-car garage, so make sure that garage is cleared out of, the tool shed and everything in there. You should be parking 2 cars in there. And then hopefully you can park 2 cars in your driveway. If you're allowed to do that, but it looks like you have a shared driveway maybe with another neighbor, so that could be the problem. I find that the way to resolve these issues is typically through communication. And unfortunately, or fortunately, they won't talk to you now that you have an attorney, so you're going to have to work through the attorneys. Or tell them that your attorney is no longer being retained to have this matter and you just want to talk one-on-one with them and see if that might work. Okay, question number 15. One more question popped in, so we have 2 left. If the homeowners agree to remove a property asset, like a tennis court, by the CC&R requirements, do all lenders on all the properties need to approve? Or is it just a percentage of lenders or no lender approval? You're going to have to look at the CC&Rs for your association. Every association has a different set of CC&Rs that reflect change of, common area use. So typically, you just need approval of the members. Some cases, the board can even do it, if the language supports that in the CC&R. So I don't think I've ever seen lenders being required to give approval, unless it's, like a major common area, like you're going to change the use and like sell it or something. I don't know. So look at your CC&Rs. I think that's the best bet to determine what approval you need for your community. The last question for today, is it legal in Arizona to take from the reserves to cover a shortage in funds for regular maintenance costs, given the large increase in costs over this past year? So is it legal? There's nothing under Arizona law, Arizona statutes that, says you cannot do this. But you really need to talk with your CPA because there are some financial issues here. And most CPAs, in my experience, what they say is that if you borrow from the reserves, you have to pay back the reserves. So you'll want to talk to your CPA about that. Also, you'll want to check your CC&Rs to see if there's anything specific that would say that you can't borrow from your reserve to pay, maintenance expenses that may have increased over the past year that you didn't budget for. So a couple things to think about. We're entering, holiday alley, so to speak. So I cannot believe that it's Thanksgiving next week. Happy Thanksgiving, everybody. Hope you have a wonderful time with your family and friends. And of course, I'm so thankful to the different cities that we work with to put on this virtual neighborhood services HOA Academy. Thanks for partnering with us this year. We really enjoy the opportunity to provide these classes, free classes for residents of many different cities in the Valley. A few things to think about as we start to, close out 2022. Our last neighborhood services presentation for 2022 is going to be on Friday, December 2nd at 9:00 a.m. So we're having a little change up on the date. Normally we meet the third Tuesday of every month, and we meet at 11 a.m. But in December, due to the holiday, we are going to have our neighborhood services Virtual HOA Condo Academy, our December class, the first Friday of the month. And this class is going to be only question and answers. So bring your questions, big and small. We will answer them all. So we really encourage you to participate by submitting questions. We'll answer every legal question pertaining to associations on Friday, December 2nd, starting at 9 a.m. And we'll keep going until we finish. And so it's for those of you who may be familiar, we're kind of combining our neighborhood services virtual HOA Condo Academy for the month of December with our first Friday virtual free call-in. So if you want more information on that, you can go to our website at mulcahylawfirm.com and click on our upcoming seminars or upcoming classes. And you can submit questions right there. And you can continue to submit questions right up to December 2nd at 8:45 a.m. So as you think of questions throughout the month, submit them there. And if you can't join us live at that time, as always, we have you can go to our Facebook Live, our Facebook page for our firm, and you can see the videos there. And we also post the neighborhood services classes always on our website. Speaking of that, our videos for our classes that we've been teaching over the past 2 years have now passed 60,000 views. So those are a great resource for everybody as you have questions on different topics. And if you want to go back and re-listen to something that I've said, they're all posted on our website, so you can look at them anytime. Okay, one final parting point before we sign off for today. We talked today about amending CC&Rs, and I just wanted to offer between now and December 31st, our firm is offering a free review, 15-minute free review of your CC&Rs and or bylaws for your association. So if you're thinking about amending your CC&Rs, we will spend 15 minutes for free reviewing them and give you feedback as to how to amend them and some things that we think you might need to change. So that's kind of a good little free thing that we're offering to our clients and to anybody who may want to become a potential client of our firm. All you need to do is email me with your request and your CC&Rs and your bylaws as an attachment to the email. And then give us about 2 to 3 weeks to do that. And then we'll get it back to you so that you can take a look at that and maybe put that on your agenda for 2023. So thanks again, everybody, for being here today. Appreciate you being here very much. And I hope all of you have a very happy Thanksgiving and safe Thanksgiving. And I will look forward to seeing you again on Friday, December 2nd at 9:00 a.m. for our last class of 2022. Thanks, everybody. Take care. Bye.